Buffy Sainte-Marie off her new album, Running for the Drum, not available yet in the States, but in an early part of this next year, it will be Running for the Drum, Buffy Sainte-Marie. Also, that was called No No Gisha Gish, which means greedy guts. Buffy Sainte-Marie. Well, here we go. Our next guest, Tom Anthony and Leon Siu, who are with the Aupuni, Hawaii, the Kingdom of Hawaii, and we'll be talking with them in a minute. The U.S. Supreme Court in October 1st, this is a release, announced that they have accepted the writ of certiorari filed by the state of Hawaii seeking to reverse the Hawaii State Supreme Court's decision of January 31st, 2008 that curtails the state's ability to sell or otherwise dispense what is commonly referred to as, quote, the ceded lands, unquote. The acceptance of the cert means that the U.S. Supreme Court will review the submitted arguments and render its decision, and the state of Hawaii is counting on a favorable ruling from the U.S. Supreme Court. At stake is the very survival of the 50th state of the Union, and the land in question is the 1.8 million acres, nearly half the total land area of the Hawaiian archipelago. That was hijacked from the government and the crown heads of the Hawaiian Kingdom in 1894 by the illegal self-declared rebel government, the Republic of Hawaii. A few years later, in 1898, the Republic of Hawaii annexed itself to the United States and in the process passed off, ceded, or the stolen lands to the U.S. And the puppet government, the state of Hawaii, is now holding the bag of stolen property deceptively called the ceded lands. And the salient point is the Republic of Hawaii did not have a lawful title or rights to these lands when they were handed over to the U.S. Thus, no lands lawfully transferred. Although this act of cession was clearly unlawful, any objections were summarily ignored, overruled, or dispatched by the bully power of the U.S. In 1959, the U.S. magnanimously passed on the stolen property, the ceded lands, as the land base for the newly created puppet government and called the state of Hawaii. Well, on board we have Tom Anthony, who is the Attorney General of the Kingdom of Hawaii, and Leon Siu, who is a Foreign Minister of Aupuni, Hawaii, which is the Kingdom of Hawaii also. I'd like to refer to Leon Siu first, his piece, his commentary on the ceded lands of Hawaii. I think the question is, Leon, is the sovereign definition. What does sovereignty mean to native Hawaiians, and the difference between the sovereignty from the Native Americans, so-called, here in the contiguous 48 states?
All right. The term Native Hawaiians refers to, of course, those Hawaiians of Aboriginal blood. But what we're talking about when we talk about sovereignty, we're talking about a nation, a political entity, which is what Hawaii was. It was an independent nation prior to this takeover by the United States. And so when we're talking about sovereignty, we're talking about the restoration of a nation, the restoration of a country, an independent country. And so, which includes not only the Kanaka Maoli, the native Hawaiians, but it includes everybody else who was a citizen or who potentially could be a citizen. So it's not a racial group, it's not an ethnic group. It's a national identity.
And the national identity, also we have online Tom Anthony. The national identity comes down to where earlier this year, January 31st, the Hawaiian State Supreme Court's decision surprised everyone. According to this, it's the commonly called the apology law. What does it mean when the U.S. Congress, signed by President Clinton in 1993, carries the force of law? And what does that decision mean to the Hawaiian people?
Well, we're not sure exactly what the function of in terms of this case, what the function of these types of resolutions are. So, we understand that resolutions do have the force of law, but they're not law as law is when an act goes before, a bill for an act goes before Congress and they create a law and that the president can veto. these types of resolutions are not subject to presidential veto. So we understand that they do not carry with it the same force of law that an act of Congress would take in its normal sense. So, and we take issue with certain elements, especially that part of the apology resolution that suggests the lands have been stolen. And this is something I'd like to clarify because I think it's important to understanding exactly what we're talking about. The lands themselves, the land itself, the 1.2 million acres, is held in trust by the government at the time, in 1893, when this unprovoked invasion occurs. So there's a question about whether the lands were actually stolen or just the right to use them or manage them was stolen. That needs to be clarified by the court. But I do not believe that the court will be moving in that direction in this case. I think the discussion will be limited to what a resolution functions as and how these particular types of resolutions can affect state rights.
And Tom Anthony, the idea of apology where lands were improperly acquired, does it have any teeth? How does that apply to it to the Native Hawaiians who basically are really the true owners? And we're talking about land here. Would it transfer? Would it actually transfer back? Because an apology doesn't mean anything really. It also means that, well, we're going to give you some money, we're going to give you some land back, but not what you ask for.
Well, the apology resolution comes about as a result of the United States needing to set up a basis for it to give its taxpayers' money to a group of people they're identifying as Native Hawaiians. And the term Native Hawaiian, as it is used by the state of Hawaii and the United States of America, finds its definition under the U.S. Code and other types of legislation that come out of the United States. This is not an identification that comes about as a result of any law of the Hawaiian Kingdom. At the time that these lands are allocated for the purposes of and uses of the government, there is no Native Hawaiian involved. There is the classification Hawaiian in terms of nationality, but not the classification that the U.S. uses today to identify a racial group. The idea over here is to turn the Hawaiians back into an indigenous people, take them out of their this civil state that they've created to manage their municipal affairs and their international affairs, and take them back into the paradigm of indigenous, so that they can negotiate under another set of rules, the rules that would not apply to an established, independent, peaceful nation such as the kingdom was in 1893, and such as the kingdom is today, I might add.
In 1893, and that apology law goes back that far. Also, there is, I'm going to refer to Leoncio, the foreign minister of the Aupuni, Hawaii, the misdirection that the state Supreme Court of Hawaii is, in your suggestion, following the lead of that apology law, deliberately misdirecting the issue and making a mere domestic problem rather than bringing it into the significant international court violations.
That's correct. Of course, they're not going to. I mean, they want to keep it domestic,